All right, let's dive deep into green cards today. Specifically, what it means for you when it's your spouse who has the green card, but you've, overstayed your visa. We're taking a look at that video you sent us. And it definitely touches on some pretty complex scenarios.
Yeah, no, for sure. And, if you're feeling a little overwhelmed right now, I get it. The U.S. immigration system, it can be a bit of a maze.
Yeah.
Especially in a situation like yours. But we're going to break it all down and hopefully, help you find some clarity.
Yeah, and looking at this video, it seems like just overstaying that visa, it really creates a hurdle when it comes to adjusting status here in the U.S. Even if you're married to a green card holder, it's not that simple.
It's not that simple, no. You see, U.S. law, it requires you to maintain what they call continuous lawful status to be able to adjust your status while you're here.
Gotcha, okay. Now, the video did mention different visa types, like student visas, work visas. Did the type of visa you had originally make a difference?
Oh, it definitely could have. For example, student visas like an F1 or a work visa like an H-1B, those often give you, more time. And sometimes that extra time allows for a spouse's green card petition to be processed before the visa expires.
Okay.
Now, if you were here on a tourist visa, a B2, those typically expire much faster. That makes it trickier to adjust your status if you're already here in the U.S.
So, okay, let's assume then that you had one of those visas that expired quickly, and now you're in this situation, married to a green card holder, but you've got that overstay on your record. What does this video suggest as a possible path forward?
Well, in this scenario, they outline a process that involves something called a waiver. And it also involves a trip to a U.S. embassy in your home country.
Oh, okay.
It's a multi-step process.
Yeah.
And it's known to take a bit of time.
Yeah, and from what I'm seeing here, I'm guessing that the I-601A waiver, that's where things get really complicated.
That's the one.
What makes it so challenging?
Yeah. Well, with the I-601A, you're essentially asking for forgiveness for that overstay. They formally call it unlawful presence. But you basically need to demonstrate that your spouse, the U.S. citizen or green card holder, would experience extreme hardship if you were denied entry.
Extreme hardship? That sounds pretty intense. What exactly qualifies as extreme hardship in the eyes of, immigration officials?
Yeah, you're right. It's a pretty high bar to clear. We're not just talking, missing each other or having some financial difficulties. We're talking hardship that goes above and beyond the typical challenges of, being apart. So think severe medical conditions, significant family ties here in the U.S. that would be disrupted, or economic hardship that could put your spouse's livelihood at risk.
Wow, so it sounds like you really need to build a strong case, a lot of evidence to show that this hardship is really exceptional.
Exactly. And gathering all that documentation, it takes time. You're talking medical records, financial statements, sworn statements from family and friends.
Yeah.
It's a pretty extensive process.
So let's walk through this a bit. After you filed the I-601A waiver, and let's assume you've got all that documentation together, what typically happens next?
Well, you'll need to be outside the U.S. while that waiver is being reviewed, which can be tough, on a family. But if it's approved, then your case moves on to the National Visa Center, or the NVC.
Okay.
And they handle all the visa application paperwork, making sure everything is in order.
And then I'm guessing, the big moment, the interview at the U.S. Embassy.
Yeah, exactly. And that usually takes place in your home country. They'll verify all your documents, ask you about your relationship, your background, your reasons for wanting to immigrate, just making sure everything checks out.
Oh, I bet that's nerve-wracking. But after all of that, and if you get through that interview successfully, then what happens?
Well, if everything goes well, they'll issue you an immigrant visa, which allows you to enter the U.S. But keep in mind, it doesn't automatically grant you permanent resident status. You'll actually get your physical green card once you're back in the U.S.
Oh, wow. So it's a lot to go through.
It is.
And we haven't even talked about wait times.
Right.
How long are we talking for this whole process?
Realistically, it could take 5 years, maybe even more, to go from filing that I-130 petition all the way to getting your green card in hand. It just depends on the processing times at each stage.
5 years. Wow. That's a long time to be separated from your spouse.
It is. But there might be a way to avoid this long, drawn-out process.
Oh. You're talking about that part in the video that mentioned waiting for your spouse to become a U.S. citizen.
That's the one. Yeah, this is where things get interesting. Because once your spouse is naturalized, it opens up a completely different path.
Okay.
A much simpler one.
So you're saying if the spouse with the green card becomes a U.S. citizen, the whole process changes?
Yeah, it really does. It's a game changer. Once they're a citizen, they can sponsor you for what they call adjustment of status right here in the U.S. No need to leave the country, no waivers, no embassy interview, and that overstay on your visa.
Yeah.
It basically becomes irrelevant.
Wow. It really shows you how much power that U.S. citizenship holds in the immigration system.
It does. It really simplifies things in these, complex situations. But of course, not everyone has that clear path to citizenship. There might be reasons why that's not an option for your spouse.
Yeah, right. Like the video mentioned, a criminal history could make it difficult to become a citizen. So what happens in those cases? What are the options then?
Well, the video does mention a couple of alternative paths, but they do come with their own set of challenges. One option is if you have an adult child who's a U.S. citizen, they could potentially sponsor you.
So my child would have to be 21 or older to sponsor me.
That's right. And there are other requirements, of course. Like they need to demonstrate that they can support you financially, show that you wouldn't become what they call a public charge, meaning reliant on government assistance.
Okay, that makes sense. They want to be sure that the sponsor can actually handle that responsibility. What about that other option the video mentioned? Something about employer sponsorship.
Yeah. But that route is usually for people with, very specialized skills, the kind that are in high demand here in the U.S. It basically means your employer would have to file a petition on your behalf and prove that they need your unique skills and can't find a qualified U.S. worker to do the job.
So that's a pretty specific and probably competitive process.
Definitely. And even with employer sponsorship, you might still run into that overstay issue. It's not a guaranteed way around it.
It seems like no matter what path you choose, there are going to be some big challenges.
That's true. The U.S. immigration system is complex, and each case is unique. There's no one-size-fits-all solution. That's why it's so important to get advice from an experienced immigration attorney.
You've said that a couple of times now. It's becoming a recurring theme. What exactly can an immigration attorney help me with in a situation like this?
Well, they can look at your specific situation, your history, your spouse's situation, the whole picture, and help you figure out the best strategy. They'll know all the ins and outs of the law, the potential problems, and how to best present your case.
So let's go back to what might be the best case scenario. Your spouse becoming a U.S. citizen. We touched on it earlier, but I want to understand that process a little better.
Sure. It generally involves several steps. First, your spouse would need to meet certain eligibility requirements, like having a green card for a specific number of years and showing what they call good moral character.
And after meeting those requirements, what happens next? Do they just, apply for citizenship?
Well, there's an application process, of course. They'll need to file the necessary forms, provide documents, get fingerprinted, and go through an interview.
That sounds pretty similar to what we were talking about earlier with the green card and the waiver process.
Yeah, there are some similarities. But the focus of the citizenship interview is different. They're testing your spouse's knowledge of U.S. civics, their English language skills, things like that.
So it's more about proving that they're integrated into American society.
Yeah.
And that they understand its values.
Exactly. And once they pass the interview and all the background checks are cleared, they'll attend a naturalization ceremony and officially become a U.S. citizen.
And then, like you said, they can sponsor you for a green card without you having to leave the U.S. or go through that whole waiver process.
Exactly. It really simplifies things for you.
Okay, but what if citizenship just isn't possible right now? And that waiver process seems like it's going to have to happen. What are some things I can do to prepare for that?
The best thing you could do is start gathering all your documentation. Get your passports, visas, marriage certificate, birth certificates, anything and everything that seems relevant.
Yeah.
Get it all organized now. Trust me, it'll make things so much easier later on.
Being organized is key. What else can I do to be proactive?
Well, take a look at your immigration history. Make note of any previous visa applications. When you entered and left the U.S., all those details. It's all important information to have when you meet with that immigration attorney.
You're really stressing that expert advice.
It's essential.
And I can see why now?
It's a lot to navigate.
Yeah.
But the more you understand the process, the better prepared you'll be. Knowledge is power, especially when it comes to immigration.
We've covered a lot today. Visas, waivers, even the possibility of your spouse, becoming a citizen. It's a lot to process.
It is.
And I imagine it can be pretty emotionally draining, too.
Oh, absolutely. The stress, the uncertainty, the potential of being separated from your loved ones, it takes a toll.
So what can you do to kind of cope with the emotional side of all of this?
Well, communication is key. Talk to your spouse, talk to your family and friends. Share what you're going through, your fears, your frustrations. Don't bottle it up. And remember, you're not alone in this. There are support groups, online forums, where you can connect with others going through similar challenges. Sharing experiences can be really helpful.
Yeah, finding that community, that sense of understanding. What about professional help? Is that something you'd recommend?
Oh, therapy can be incredibly beneficial. It can give you tools to manage the stress and anxiety and help you navigate the ups and downs of this whole immigration process. So if you're feeling overwhelmed or just struggling to cope,
Yeah.
don't hesitate to reach out to a therapist. It's a form of self-care, just as important as tackling the legal aspects.
That's a really good point. Taking care of yourself through all of this. So as we wrap up, what's the one key takeaway you want to leave with?
I think the main thing to remember is that even though marriage to a green card holder, when you've overstayed a visa, yeah, it definitely presents challenges. There are options available. It just comes down to careful planning, being organized with your documentation, and seeking that expert legal advice. Don't lose hope.
Well said. It's been a deep dive, but hopefully you're feeling more informed, more empowered.
I hope so.
Knowing what you're up against, that's half the battle.
Exactly. Knowledge is power.
Now that you have a better understanding of what's involved, what steps will you take next to, secure your future with your spouse? Remember, taking informed action is key. We encourage you to reach out to an experienced immigration attorney, discuss your specific situation, get that personalized advice. Good luck on your journey. And thanks for joining us on the deep dive.
Hello everyone, welcome back to our channel US Immigration News. We hope you are doing great. Well, in today's video, we will be talking about navigating life with spouse who has a green card. Being married to a green card holders while having overstayed your visa presents significant challenges under US immigration laws. If you have fallen out of lawful status, the government generally does not allow you to adjust your status and obtain a green card while remaining in the United States. Maintaining continuous lawful status is crucial to be eligible for adjustment of status through your spouse. For example, individuals with visas like F1 students or H1B work visas, which allow extended lawful presence, may be able to adjust their status if their visa remains valid throughout the application process. However, temporary visas like B2 tourist visa are often too short in duration, leaving many without this option. For those who have overstayed and are out of status, adjusting a status through a green card holder's spouse becomes impossible under current laws. In such cases, a waiver and consular processing are required, involving multiple steps and lengthy waiting period. First, your spouse must file Form I-130 petition for like relative to stabilize your relationship and set your priority date for an immigrant visa. If the I-130 is approved, you will then need to file Form I-601A, a request a waiver for unlawful presence. This waiver process alone often takes 3 to 4 years. Once the waiver is approved, your case proceeds to the National Visa Centers for visa application processing, followed by an embassy interview in your home country. Only after completing this process and receiving an immigrant visa can you return to the US as a lawful permanent resident. The entire process can take 5 or more years due to extensive backlogs and processing times. A simpler option is to wait for your green card holder spouse to become a US citizen. Once your spouse is naturalized, you can adjust your status without needing to leave the US, even if you have overstayed your visa. However, this solution is not always possible, especially if your spouse is ineligible, your naturalization due to criminal history or other complications. In such cases, alternative pathways may include sponsorship by an adult US citizen, child age 21 or older, or employer sponsorship. Though these options often still require an I-601A waiver and consular processing. Navigating these complex scenarios requires careful planning and patience. The process for individuals out of status is lengthy and often emotionally taxing, but potential solutions depend on the specific circumstances. Consulting with an experienced immigration attorney can help identify the best course of action, whether it involves waiting for a spouse's naturalization, pursuing a waiver, or exploring alternative sponsorship opportunities.